Thank you for joining us today. My name is Daniel Hernandez, and I'm a staff attorney with Disability Rights California. I use he, him pronouns, and for accessibility purposes, I want to provide a short visual description of myself today. I'm a Latino man with black hair, a dark beard, and a mustache. I'm wearing black framed glasses and a black polo shirt today, and my background is blue with our organization's logo in the top corner. So today's topic will be alternatives to conservatorship. Before we move on to the next slide, we want the audience to know that as advocates for people with disabilities, we will do our very best to always protect a person's right to be independent as possible, or to maintain autonomy, or to promote self-determination, meaning that a person should be allowed to make decisions about how they want to live their lives. That said, we also understand that every person has specific needs and every situation is different. But of course, as people with disabilities and as loved ones or family members of people with disabilities, we should always pursue the least restrictive option or the best alternative when it comes to conservatorships or alternatives to conservatorship. Now, on this slide, you see a disclaimer, a short disclaimer that the following presentation is meant for education only and doesn't constitute legal advice nor counsel. And that's because your situation may be unique and require careful attention beyond what this presentation can provide today. Also, please keep in mind that the information in these slides may change in the future, and that's because the laws and local practices related to these matters can develop over time. Another disclaimer I would like to make is that during this presentation, we will not be discussing Department of Developmental Services, or DDS, conservatorships. For those who are not familiar, DDS conservatorships are situations where the California Department of Developmental Services becomes a conservator of someone with an intellectual or developmental disability. Though I should note that Disability Rights California does have a specific unit or program called PULSE, or PULSE, which stands for Peers, Understanding, Listening, Supporting, and Education. And this program provides support to individuals that are conserved by DDS. Also, today's presentation will not cover LPS conservatorships, which are involuntary conservatorships that are initiated by local government agencies for people with severe mental health disabilities or severe substance use disorders. So as a disclaimer, we will not be covering DDS conservatorships nor LPS conservatorships today. So now let's provide an overview of what we will cover today. So we'll cover several key areas. We'll start with context about conservatorships and why they may be sought. We'll also discuss the risks of general conservatorships. We will then go on to discuss limited conservatorships, supported decision-making, and various other options or alternatives to conservatorships. And we'll frame these in three different areas, including healthcare, finances, and education. And at the end of the presentation, we will also provide a list of various resources where you can learn more about all of these different options. Now, the main question we often get, right, is what is a conservatorship? And here on the screen, the reason why we have the word general in brackets is because we want to point out that general conservatorships are different than limited conservatorships, which we will discuss later in the presentation. So a general conservatorship is created as a result of a court hearing before a judge. So under the law, a person, or more specifically, an adult, is presumed to have capacity to make decisions for themselves, unless a court finds otherwise. If the court finds otherwise, a conservatorship can be created or established. So if a conservatorship is created, the appointed conservator makes decisions for the conservatee. In other words, a conservatorship is a legal arrangement. It's established when a court or a judge decides that someone, which we call the conservator, needs to make decisions for another person, which we call the conservatee, or the person under conservatorship. So the court will provide this authority because after reviewing information and after a hearing, a judge has decided that a person cannot make decisions on their own. And there are two types of areas within a general conservatorship. We have conservatorship of the estate or a person's assets and conservatorship of the person. Let's first explain what a conservatorship of the person is. So a conservatorship of the person is where a conservator is given authority to make decisions about a person's healthcare, who the person sees and spends time with, where the person lives and with whom, who the person dates or has sexual relations with, their personal care, or even decisions about their daily living needs. A conservatorship of the estate is different. A conservatorship of the estate is where a conservator is given authority to handle a person's financial matters, such as managing their benefits, paying bills, really anything related to the person's money, if it's necessary, of course. So another question we often receive is why do people seek conservatorships? What is a goal? What is a purpose for people seeking conservatorships? And before I do discuss that, I do want to describe the graphics that are on the slide here. There are two large arrows. The one on the left is blue and the one on the right is green. The arrows contain text and the arrows are pointing to each other, which indicates that there's a common goal. In this case, seeking a conservatorship. So there could be various reasons why people seek a conservatorship. For instance, they're told by a person's school or their doctor that a conservatorship should be pursued. Or people decide to pursue a conservatorship because they have concerns about a family member's healthcare, about their access to doctors or services, or because they're concerned about financial abuse. So often parents or family members are told that a conservatorship is necessary. And many parents and families think that a conservatorship is the only way to make sure that their loved one is cared for. These are valid concerns, but the question we like to pose is a conservatorship the only solution in this situation? Which we'll discuss more thoroughly in the next few slides. So let me describe the graphics on the slide here. There's a yellow box with two columns of text. The left side of the box has a blue arrow that's pointing upward, indicating why conservatorships may be needed. And the right side of the box has a blue arrow pointing downward, indicating why a conservatorship is never needed. So, like I mentioned before, every person has specific needs and every situation is different. So we understand conservatorships may be needed in some situations. And here we have examples of when that might be the case. For example, in emergency situations, such as incapacitation, when a person did not identify how decisions should be made, or no one else is available to make decisions for a person who is deemed unable to. Another situation can be when a person has never been provided supports to make or communicate their decisions. Again, every situation is different, and we have to identify the best choice or option for the person with a disability. That said, conservatorships are never needed just because a person has a particular diagnosis. For example, schizophrenia. Or when we think a person needs overall help in life, because a person is seen as someone that has to be cared for like an infant or a child. And a conservatorship is never needed just because we are told that it's the norm and that it's something that's expected. That's never the case, right? You sometimes hear affirmations like, that's the way it has always been. And that's not necessarily the case. Okay, so now let's talk about the risks of general conservatorships. Though conservatorships provide authority to make decisions on someone else's behalf, there's technically no extra protection against the following: financial scams, physical abuse, sexual abuse, or police arrests and/or jury convictions. This is because authority or power is given to another person and sometimes people, and humans are not faultless. So there are always going to be these risks. Also, conservatorships can be a permanent decision. Reversal can be difficult and expensive. Though later on, we will talk about some changes to the law that provide an extra layer of protection for people under conservatorship, which is a very beneficial law to people with disabilities in California. Also, court checkups of conservatorships can sometimes lead to problems. So what does that mean? So if a conservator is not equipped to adequately help a conservatee, there can be intense scrutiny by investigators or the court. And this can affect the support that the conservatee ultimately receives, which is not a great situation to be in. Also, there are important considerations for when a conservator passes away. For example, let's think of a situation when an older parent is a conservator and they pass away. So in that situation, a court can end up controlling the conservatorship. The chain of succession may not be honored, meaning that a conservator's wishes of who they want to be a conservator is not considered. Or a professional conservator may be appointed. And again, you cannot control who would be ultimately appointed. So despite all of this, I will reiterate that people under conservatorships do continue to maintain rights, even if they are in a conservatorship. At the end of the presentation, we have a few slides with resources listed, and resource number 1 will take you to a court form that lists the rights of a conservatee. Some of these rights include the right to be represented by a lawyer, to ask a judge to replace a conservator, to ask the judge to end the conservatorship, and other rights. So now let's talk about the importance of alternatives to conservatorship or general conservatorship. Why should we think of other options before pursuing the most restrictive type of decision making, which is a general conservatorship? Here we have a list of considerations that can help you determine whether general conservatorship is a correct option. First, a conservatorship it technically takes away a person's rights to make important decisions about their life. Is that something that someone wants to pursue? Also, the court will become a part of both the conservators and the person's life going forward. Also, conservatorships can change relationships. So if a person is forced into a conservatorship, despite their wishes, it can change the dynamic of a relationship. Also, conservatorships can take time and cost money. because a conservatorship is a process that takes place through the courts. Also, another very important aspect of considering alternatives is that to establish a conservatorship, a judge must find that a conservatorship is a least restrictive alternative. And this is due to changes in the law, which I'll discuss a bit later. But this means that all available alternatives to a conservatorship have to be considered and determined to be insufficient before a conservatorship is established. And on the slides where we have our resources at the end of the presentation, you will find resource number 2, which contains a sample of a conservatorship packet, which provides an example of how a court assesses the need for a conservatorship through various forms and processes. Here, let me provide a description of the graphics on the slide. There's a yellow box with a question. What is the goal? There's a blue arrow pointing downward with the answer, keep people as independent as possible and let them shape their own lives, self-determination. So once again, what is the goal of considering these alternatives? It's to keep people as independent as possible and to let them shape their own lives, which we previously described as autonomy, right? Or promoting self-determination. So here on the slide, we have a list of all these various options, right, as an alternative to a general conservatorship. First, we will provide information about limited conservatorships, which again is different from a general conservatorship. And though it is part of a judicial or court process, it is generally less restrictive than a general conservatorship. And then to the right of the text, you will find the white icon of a courthouse with 4 columns or pillars. So subsequent slides with this icon indicate that the slide contains information about limited conservatorships. Next, we have other alternatives to conservatorship that allow families or trusted individuals to help people with disabilities without resorting to the most restrictive form of control or conservatorship. We have supported decision-making, which is a legal agreement or arrangement that supports people with disabilities in making important decisions in their life. And to the right of the text, you will find the white icon of 4 hands that are facing inward. So subsequent slides with this icon indicate that the slide contains information about supported decision-making. And to the right of the text, you'll also find the icon for options, which is a set of 3 lines with 1 white circle in varying places of the lines. And slides with this icon indicate that the slide contains information about other options or alternatives to conservatorship. Some of these options or alternatives include power of attorney, advanced health care directives, releases or HIPAA forms, or HIPAA forms, special needs trusts, Representative Payee designations, payable accounts, joint bank accounts, automatic bill pay arrangements, and assignment of educational rights. So how does one choose the best decision-making strategy? Here we have a list of questions we can ask ourselves to determine what the best approach is to assist a person with decision-making. So first, what kind of decision needs to be made? For example, does a person simply need help making decisions at an individualized education program or IEP meeting? now that they're an adult? How much risk is involved? How hard would it be to undo the decision? Has a person made a decision like this before, where they didn't need a lot of help? For example, let's say a person has been able to express in the past what school they wanted to go to. Do we want to restrict their ability to do that moving forward? And the ultimate question is, what is the least restrictive support that might work in any given situation? So now we'll turn to the topic of limited conservatorships. And on the screen, you'll see the icon of a courthouse with 4 columns or pillars, indicating we're now discussing limited conservatorships. So limited conservatorships are reserved for people with intellectual or developmental disabilities, such as autism, cerebral palsy, epilepsy. Again, to establish a limited conservatorship, one must undergo a judicial or court process. And unlike a general conservatorship, a limited conservatorship provides a few areas of authority to a conservator. And there are 7 of these. And here we have a list of those powers. 1, the right to determine a person's place of residence, the right to view confidential records, the right to marry, the right to sign contracts, the right to consent to medical treatment, the right to control your social and sexual contacts, and or the right to make decisions related to education. So these are powers or areas of authority that can be provided to a conservator under a limited conservatorship. And it could be some of these or all of these. It really depends on a person's specific circumstances and situation. And again, this will be part of the judicial process. So the last slide listed the powers that a limited conservator has. Here we have a list of powers or areas of authority that a conservator does not have. So the conservator cannot do any of the following: control the salary or allowance of the individual, approve harmful medical treatments, force a person to carry out drug treatments, force a person to sterilize or to restrict or terminate their ability to procreate. Also, a conservator cannot place a person in an institution without their consent. The conservator cannot force the person to undergo electroconvulsive or electroshock treatment. And a conservator cannot force a person to undergo psychotherapy. So as we mentioned, there is a court process involved with pursuing a limited conservatorship. And various entities play a role in this process of establishing a limited conservatorship. We have investigators, we have regional centers, and we also have court-appointed attorneys. So we'll discuss what role each one of these plays in the process. We'll start with the role of the investigator. So during the process of trying to pursue a limited conservatorship, a court investigator is assigned to the matter. They interview the person and they inform the person of the process. So within this, the investigator will determine if the person with a disability is able to attend the hearing, whether they oppose a conservatorship, and whether they oppose a proposed conservator. Do they want someone else to be the conservator, in other words? The investigator will also interview others, including family members. And the investigator will make their own determination if there is a need for a conservatorship. And they'll also determine whether the proposed conservator is suitable. And a report of all of this information is provided to the court and the judge. Now, we mentioned that limited conservatorships are generally established for people with developmental or intellectual disabilities, so regional centers play a role in the process as well. So the regional center will actually evaluate the person and file a report with the court. And the report will contain a lot of information, but the basic information that it should contain is the nature and degree of a person's disability, the type of assistance that's needed, a person's physical condition, a person's mental condition, and information about their social well-being, and recommendations on the powers that are being requested in the petition or request to establish a conservatorship. So again, there are 7 powers, or areas of authority. So the regional center will make a judgment about what areas it recommends be provided to conservator, if any. And this report is confidential, and it has to be filed with the court at least 5 days before a hearing. And the report is also provided to all parties so that they can inspect it. Now, the role of the court-appointed attorney. Again, people that are being assessed for a conservatorship have rights. One right is to be represented by a court-appointed attorney. So this attorney will meet with the person to discuss a conservatorship and their rights. And the court-appointed attorney will also file a report to the court and will also present the information at the hearing. And they will tell the court what the person with the disability wishes and what they desire in this process. So before establishing or creating a limited conservatorship, a judge has to determine by clear and convincing evidence that the limited conservatorship is necessary to promote and protect a person's well-being. So you see the phrase clear and convincing evidence italicized. And the reason why is because this is a term of, it's a legal term, which is the clear and convincing evidence is a standard of proof, which generally means that a judge looked at all the information and evidence, and the judge has concluded that it's highly probable that the person needs a conservatorship. And let me provide a little bit of context about legal standard of proof. So a conservatorship proceeding is a civil court matter. So there's generally 2 standards of proof when it comes to civil court matters. 1, preponderance of the evidence, and 2, clear and convincing evidence. Preponderance of the evidence means that it is more likely than not that something is true, or there is a 50% chance that it's true. Clear and convincing evidence means that it is highly probable, or that there's a 70 to 80% chance that something is true. So here, a judge has to find that it is highly probable that the person needs a conservatorship before it can be established. So that was some information about limited conservatorships, and we didn't cover every single aspect of a limited conservatorship, but we did provide a general overview, so you have an understanding that it is an option. Now let's talk about supported decision-making, which I'm a great fan of. And on the screen, you'll see the icon of 4 hands that are facing inward. So I mentioned that this is a legal arrangement. This is a concept or a tool that's recognized by California law. But what is supported decision-making? So this is an approach that helps people with disabilities make life choices that mirror how everyone else makes decisions. It gives people the help they need and want to understand situations and choices they face so that they can make their own decisions. And this is a legally recognized alternative to a conservatorship that can strengthen the capacity of a person and avoid the need for a conservatorship. So that's generally what supported decision-making is. But now let's dive a little bit into the law that helped create this legal tool to support people with disabilities. So as of January 1st, 2023, supported decision-making is California law. So it requires entities across the state to recognize supported decision-making as a legitimate tool or support for people with disabilities. And in doing so, a person can create or establish a supported decision-making agreement. And so through this agreement, people with disabilities can maintain capacity to make their decisions, but they can choose people, which are known as supporters or a circle of support, to help them make, understand, and communicate their decisions. But the person with the disability will make the final decisions about their own life. But this law allows people to be, quote unquote, present in the room so that they can support a person in making decisions. And a person does not need an attorney to create these agreements. And at the end of the presentation, we provide a list of resources, and there are samples to these written agreements that can be completed and notarized. And they do take legal effect, meaning they are legally recognized as supports for people with disabilities. So in practice, how does supported decision-making look? So under a supported decision-making agreement, supporters might help review bank statements, attend doctor's appointments to take notes, or help explain complex choices in plain language or in a way that the person with a disability can understand. So let me provide an example. Let's say I have an adult brother that I have grown up with my entire life. And he is a person with autism, and he has specific communication needs. And as someone who has spent my entire life with my brother, I know how to communicate his needs. He expresses things in a very specific way, and I can understand his wants and desires. So a supported decision-making agreement allows me to be present at the doctor's office to help facilitate communication. I could explain to a doctor, this is what my brother is trying to communicate. This is what he wants. This is what he needs. And that's protected by law, right? That person can be present in the room to help another person make decisions. And this law also created other changes. For example, petitions for conservatorship will not now, but have for some time now, a few years now, included alternatives to conservatorships, right? And it has to be confirmed that they were tried or considered. And they have to explain why alternatives were not appropriate, if that's the case. This law also requires courts to provide conservatees with information regarding their rights, which I explained you can find in the first resource that we provide in our section regarding resources. And also now a court can terminate a conservatorship without a hearing if a conservatee and a conservator agree, which is a great change. And on our resource slides, you'll find resource number 3, which is the specific language of this law, also known as Assembly Bill 1663 from the 2021-2022 session. You'll also find resource number 4, which is a frequently asked questions document about supported decision-making. So something that we would like to highlight is that anybody can have capacity with supports. And let me use percentages to describe this. So let's say that a person's capacity is 40%. what can we do to bring that capacity to as close as we can to 100%? So instead of asking the question, what could this person do all alone on a deserted island? In other words, what if we put a person on a deserted island where they don't have access to any resources or tools? That person would not be able to achieve much, right? They wouldn't have much capacity, let's say. But let's say that even if this person is on a deserted island, what could that person achieve with help and guidance from their friends, their family, and professionals? In other words, their circle of support or their supporters. What could this person achieve with technology, with education, with some patience and practice? And inevitably, these supports will help someone achieve more capacity. You can reach, well, as much as you possibly can, right? You can strive for 100%. And these supports will help you achieve that. In this way, a person with a disability can have capacity with supports. And the truth is that everybody seeks help with difficult decisions, whether you're a person with a disability or not. And people without disabilities are often encouraged to seek help. So people with disabilities deserve the same, right? They should be part of any decision-making process. They should be entitled to supported decision-making. Now, in the next few slides, we'll be talking about how supported decision-making and other alternatives can be used in real-life situations when it comes to healthcare, finances, and education. And on this slide, you see various icons to notate healthcare, finance, and education. So the icon of a stethoscope on a blue background is a symbol for healthcare decisions. The icon of a stack of cash on a gray background is a symbol for financial decisions. And the icon of a stack of books on a yellow background is a symbol for educational decisions. So let's first talk about healthcare decisions and supported decision making. So under supported decision making in healthcare, support is often required to understand health information, to communicate with providers, and to manage daily health needs. So what can trusted support, a circle of support or supporters, what can they do to help with this decision making? Supported decision making can help someone access their healthcare needs, understand medical information, and help make medical decisions. And again, supported decision making is a legal tool. It's recognized and protected under California law. So supported decision making is an option. But when it comes to healthcare, we have other options. We have, for example, a power of attorney, which is a legal document where one person gives the legal right to someone else to make decisions for them. And a power of attorney can be general or limited. It can also be durable or springing. Sometimes people, instead of saying a springing power of attorney, they will use the term conditional power of attorney. So I'm going to take a few moments to explain all of these concepts as they relate to power of attorney. So let's start by first providing an explanation of the difference between general powers of attorney and limited powers of attorney. So a general power of attorney is one that gives broad authority to make decisions. It is only effective while a person is alive. It's not effective if a person passes away or becomes incapacitated. Some examples of when somebody may be deemed incapacitated can be if they can't understand or communicate with others anymore, if they no longer recognize people or things that were once familiar to them, if they are experiencing severe delusions or hallucinations, or if they don't understand the consequences of their actions. So a general power of attorney gives broad authority to make decisions, and it's effective while a person is alive, but no longer effective if they become incapacitated. A limited power of attorney, on the other hand, is a person's authority, a power of attorney where a person's authority is restricted to only specific situations or tasks. So I can have a power of attorney that gives someone authority to just manage or make decisions about my finances, but nothing else. So a limited power of attorney will only provide authority in areas that have been specified or identified, not all areas. Now let's explain the difference between a durable or conditional power of attorney. And a conditional power of attorney is sometimes known, like I said, as a springing power of attorney. So a durable power of attorney is one that will continue to be effective even when a person becomes incapacitated. A springing power of attorney, on the other hand, is different. While other powers of attorney take effect immediately, a conditional power of attorney will only take effect after an event happens. For example, I can have a power of attorney that states that my mom has authority to make decisions on my behalf only when I'm unable to understand or communicate with others. Until then, I can make my own decisions. But if I become incapacitated, I want my mother or my mom to start making those decisions for me. So powers of attorney generally don't require the involvement of an attorney, right? There's definitely a lot of resources out there that can help you create a power of attorney. And these documents are legal documents. Of course, they have to be signed and notarized, but they do carry legal weight. And something else that I will add is that for medical decisions, a medical power of attorney is usually part of an advanced healthcare directive, which leads us to our next option. So an advanced healthcare directive is a legal document that outlines the preferences for future medical care when a person is unable to make decisions for themselves. And there are two important components to an advanced healthcare directive. One, a person has to name their choice of who they want to make decisions for them. And two, the Advanced Healthcare Directive has to provide instructions or specific instructions. And advanced healthcare directives will usually go into effect in specific situations. For example, if you're in a coma, if you're mentally incapacitated or can't communicate anymore, or if a court finds you incompetent to make medical decisions due to mental illness, for example. Another option is a Health Insurance Portability and Accountability Act, or HIPAA release form. And this is a legal document that gives a healthcare provider permission to share a patient's protected health information with a third party. In other words, it's a form that is signed by a patient that allows a doctor or healthcare provider to share that patient's medical information with a third party, such as a family member. And on our resources slides, you will find resources number 5, 6, and 7. And these resources contain information about powers of attorney, about the law regarding advanced healthcare directives, and a sample of a California advanced healthcare directive. Now let's talk about financial decisions. Supported decision-making with financial decisions, specifically. So under this arrangement, support is often required to understand financial information, to communicate with banks, and to manage money. And supporters or a circle of support can help with budgeting, managing bank accounts, paying bills, and communicating choices to financial institutions, even. So now let's discuss other options other than supported decision-making agreements. So we can have a power of attorney to help somebody make financial decisions. Somebody can also be designated a representative payee to help manage Social Security benefits. So Social Security Administration, or SSA, is a federal agency, and it's the agency that provides Social Security benefits. So to help manage a person's benefits, Social Security will ask them to fill out a form if needed to select a person that can help manage their money or Social Security benefits. So the person that helps manage the money or benefits would be known as a representative payee. And something that I will note is that supported decision-making agreements, right, this is protected under California law. However, Social Security Administration is a federal agency, so they are less willing to accept a supported decision-making agreement when it comes to helping somebody manage a person's Social Security benefits or their money, let's say their SSI benefits. But in that situation, it's important to note that a supported decision-making agreement can have a representative payee designation attached to that agreement. So it all works together. But that's something I do want to note, that for federal agencies, supported decision-making agreements may function a bit differently. A person can also have a joint bank account, or where they would have access to an online account and receive notifications for someone. Though I will say, if you do receive supplemental security income or SSI benefits, please avoid joint bank accounts. And that's because the SSI program has resource limits. So if you do have a joint bank account, any money in that account can affect SSI eligibility. I do want to provide that small warning. Another tool that can help with finances or help support somebody with finances is a California Achieving a Better Life Experience, or CalAble account, which is a tax advantage savings and investment account for eligible individuals with disabilities. And this allows them to save over $2,000 without losing public benefits like SSI. And there's an asterisk here because the resource limit varies depending on living situation. For an adult, the resource limit is generally $2,000. For a couple, it's $4,000. And if it's a child that receives SSI, the resource limits are different as well. That said, a CalAble account can help make sure that you do not exceed these resource limits, and it'll protect your eligibility for benefits like SSI. And we won't be discussing CalAble accounts today, but we do have a webinar later this month where you can learn all about CalAble accounts. So we do encourage you to visit our events page so you can register for that webinar. Another helpful tool to help support a person with a disability with their finances is automatic bill payments from primary accounts. So let's say that you're helping someone that has their own apartment, but they need help with money management. You can set up automatic bill pay so that for example, the internet bill is paid on time and for the exact amount. Also, another resource can be found through the regional centers if you're a regional center client or consumer. And that's through independent or supported living services, which are specific services that can help a person with a disability, an intellectual developmental disability, manage their finances, right? Or help them with money management. Another option is a special needs trust. which generally speaking is the situation where you would find the need for a special needs trust is if you receive a large inheritance or come across a property with a substantial value. So in this situation, a special needs trust, which is a legal tool, legal account that is established to manage funds of a person with a disability. And that's part of a judicial and court process as well. So the court will have a trustee or assign a trustee to manage money in the trust. And essentially anything having to do with the money or management of the money has to be done through a trustee. Okay. Now let's talk about educational decision making, right? Through supported decision making. So under the law, children are not generally recognized to have the capacity to make decisions on their own. For this reason, parents are often the decision makers for their children. So many minors with disabilities are not given the ability to make choices or learn from their mistakes when they're in school, right? Or if they're in special education, for example. And schools commonly promote conservatorships as the only option, or they don't allow children to be part of the decision-making process. So it's important to practice decision-making from the earliest age possible. And here we have some practical tips that can be useful for people who are in special education, or even if they have a Section 504 plan, or even if they're not in one of these programs. It could be general, practical, useful information for families. So students should participate in their educational planning, right? Or individualized education program or IEP meetings when it's appropriate. Goals or IEP goals should be ambitious and promote student involvement. And IEP goals should target self-determination, self-advocacy, and problem solving. In other words, when it comes to a person's schooling and education, wherever possible, children or minors should be part of the decision-making process. And that's how they slowly learn to make decisions for themselves. So apart from supported decision-making, how else can you support a person with educational decisions? One, the through line, right? A power of attorney. That is always an option. We also have assignment of educational decision-making rights. So when a student turns 18, they retain decision-making rights under the law. However, a student with a disability may need support in making educational decisions when they become an adult. So unless they are in a conservatorship, where a judge has deemed them incapable of making educational decisions, a student with a disability that is an adult can give written permission to a parent or a trusted person to make decisions on their behalf. And this is known as an assignment of educational decision-making, which is an agreement, a contract, and it does carry legal weight, and it has to be recognized by schools and school districts. So this, again, will provide a parent, a legal guardian, or trusted individual decision-making authority for a student once they turn 18 years of age. And on our resources slides, you'll find our resource number 8 and resource number 9, which provide sample letters or agreements of an assignment of educational decision-making authority, which can be printed out. And if a person with a disability or student is deemed to be capable, right, under the law to enter into a contract, they can sign that agreement and it can be provided to the school. And that would give a parent or a trusted individual legal authority to make this educational decisions on behalf of the student with the disability. So here in the next few slides, we have a list of various resources. And and a lot of them I did reference throughout the presentation, specifically resources 1 through 6 here, and then 7 through 9 on this slide. But we also have some other useful resources. For example, we have a link to ACLU supported decision-making library that provides a lot of great information about supported decision-making as a legal tool. We also have here on resource number 12, supported decision-making handbook for parents of adults with developmental disabilities in California. It's an extensive handbook, which is presented in plain language, easily understood language that you can refer to. It's very helpful. And here, lastly, on this resource page, we have a link to California Court's self-help resource for alternatives to conservatorship. So as I mentioned before pursuing and establishing a conservatorship, it now has to be determined that alternatives were not adequate or could not work under a given circumstance. And so this webpage lists a lot of these different alternatives and provides more information, a lot of which we discussed today. And lastly, the last 3 resources provide more information about supported decision-making, again, as a legal tool, particularly in California, that has legal weight as you interact with various agencies or offices and when you're supporting a person with a disability under such an agreement. And here on this slide, you'll find information on how you can contact Disability Rights California should you encounter a legal issue pertaining to alternatives to conservatorship. What I will mention is that DRC, as an organization, we don't help establish conservatorships, right? That is not something that we pursue because, again, we do our very best to maintain a person with the autonomy of a person with a disability. But should you encounter issues with alternatives, feel free to contact our intake line. The number is 1-800-776-5746. You can also contact our TTY number, which is 1-800-719-5798. Our intake line is open Monday, Tuesday, Thursday, and Friday from 9 a.m. to 3 p.m. And if you cannot contact us within these hours, you are free to submit an online form. And we have the link here. And if you are a regional center client, you also have the option of contacting the Office of Clients' Rights Advocacy, which can also help with various legal matters. And their intake line is 1-800-390-7032.